Welcome to the City Council 5 p.m. work session for ethics and liability training with Sam Light, the legal counsel from CIRSA, our insurance pool and carrier. Sam, if you would please, I'm going to turn this over to you.
Thank you, Mayor.
You're welcome.
Thank you, Council. Thanks, staff. Good to see you all. Thanks for having me out. Appreciate the invitation to come visit.
Appreciate having you.
Just by way of further introduction, so I'm Sam Light, and I need to stand near the mic. I better do that.
You couldn't take it off there. You do have to hold it.
All right, I'll stay close.
Sorry.
And I'm the Deputy Executive Director and General Counsel for CIRSA. And CIRSA is an acronym, by the way. It stands for the Colorado Intergovernmental Risk Sharing Agency, which is quite a mouthful, which is why we call it CIRSA. So CIRSA, as your insurance provider, you're a member of our property and casualty program, as well as our workers' compensation program. And part of what we do, I'm going to explain a little bit more about CIRSA in a moment, is that we offer trainings for our members, for all individuals within the organization. We provide training at the elected and appointed official level, which is our presentation this evening, as well as trainings for staff, folks in operations or administration or what have you. So thanks for the opportunity to come visit with you all. Here's a little historical footnote for you. You know, CIRSA is a member-owned, member-controlled organization, and pooling is different than commercial insurance, right? We're not a commercial regulated insurance carrier. We're a public entity self-insurance pool. And our only book of business, our only insurance is insuring Colorado cities and towns and affiliated entities. And what that allows us to do, we were formed back in 1982, allows us to form close and long-standing relationships with our members. And in that vein, the historical note is that City of Woodland Park's been a participant in our property and casualty program since 1985, almost since the beginning of CIRSA, and a participant in our workers' compensation program since 1989. So thank you very much. We greatly value our relationship with the city, and we're very proud of the fact that we're able to help you and your community move forward. I know that risk management insurance is not the most attractive topic to everyone, right? But in a pooling environment, right, I think rather than have shareholders with a profit motive, look at it only as a financial transaction. Part of what we do in pooling is we provide the resources to help our members and their communities succeed, right? Find ways to provide coverages, give you resources that help you work through issues and help you, insure risks that help you, whatever your community's got in mind, provide coverages that help you get your community moving forward, whatever direction you want to take it. So just a little bit more about CIRSA. To give you a sense of our size, we've got 294 members. That's about 90% of the cities and towns in the state of Colorado that we insure, together with affiliated entities like housing authorities or renewal authorities, some regional transportation, regional 911 authorities, things like that. We're located out of Denver. You can go to www.cirsa.org and learn more about our organization. But one of the handouts that I put at your places is a document called CIRSA at a Glance. And it gives you a sense of the resources that we provide to our members that are there for you to use, as much or as little as you would like as an organization. The things that we offer in addition to what I call the bread and butter. Yes, we deal with the bread and butter stuff. Get the renewals in place, the coverages in place, issue the certificates of insurance. We've got this group that you probably have to interact with every now and then. That's our claims department. They take care of all that, right? But we've got other resources for you as well to help you around risk issues. And that handout talks more about that issue. So again, thank you for your membership in CIRSA. As I said, we offer all sorts of trainings, and our time together this evening is to help you all think about risk management issues at the governing body level. At a pooling level, right? We really have this attitude at CIRSA that, just as you're working locally, right, to be good stewards of the interests and assets of the city of Woodland Park, we kind of aggregate that up and believe that it's our shared responsibility to each individual member and to the pool as a whole, right, to have good risk management practices at all levels of the organization, right? And maybe you agree with this notion, but we believe that a good approach to risk management, good resourcing of risk management starts at the highest levels within the organization with the governing body and the elected and appointed officials. So myself and our associate general counsel and our executive director, we're the team that gets out there every couple of years. We usually try to schedule visits around election time, or we do them on an interim basis, but to come out and do presentations for you all at the governing body level. So let's go to the next slide. I do want to make our time together as useful to you all as possible. So if you have questions, feel free to grab my attention and we'll deal with your questions. I know that Suzanne, a former member of SURS's board, put at your places copies of our slide deck and along with the other handouts. So if you have questions, we can talk about those as well, because the other materials will be there for a resource for you. Okay, so in terms of what I'm going to present, though I am an attorney and I'm happy to answer some questions on the legal stuff, that's really for Jeff and his team. But I try to focus the presentation around suggestions, really, for best practices, for best risk management commitments at the governing body level that I think will help you individually and collectively as elected officials or as appointed officials on the planning commission, help you succeed both individually and collectively. So we're going to talk about the fiduciary responsibility of being a local government official in Colorado. We'll talk about transparency just a little bit, because I'm sure you've gotten training from the clerk's office and the manager's office and the attorney around the open meetings law, but I'll tell you a couple of things that are on our radar. We'll talk about organizational structure and liability. That's a critical concept to protect yourself both individually and collectively from liability, is to understand how organizational structure influences your risk exposure. And then particularly for the planning commissioners and also the council, we'll talk a little bit. We do a separate training on this issue, but I'm happy to come back and do that if you haven't heard enough of me by the end of this presentation. I'm happy to come back and talk more about quasi-judicial proceedings, but I just want to get on your radar some additional responsibilities that you have related to quasi-judicial matters. Okay, so as I mentioned, this is a training resource only. If I see a couple familiar faces that have sat through my presentation before, just a gentle reminder that though I am an attorney, this is not an attorney-client discussion, right? So again, feel free to ask me questions if you have those, but if my radar is going off telling me that this is the live burning question of the day, right? You know how it goes. Sometimes people ask me in the train, hey, Sam, what if another member of the town board does this? And everyone peeks up and goes, wow, this is going to be an exciting discussion. My radar is telling me that's for Jeff and his team.
You'll see me, Joe.
Yeah, absolutely. And same thing if it's something in your city manager's wheelhouse, because I don't know what you got going on as far as your workloads. I could sense that, hey, this is for Aaron and his team. And those two comments segue into one of my most important risk management suggestions for you at the governing body level, because at the end of the day, right, we're all, you get paid just a little bit maybe, or you completely volunteer. Yeah.
All volunteer.
We're all volunteer. We're all citizen volunteers, right? On a citizen, multi-member volunteer public body. And we were never asked when we put our name on that ballot or stepped for that appointment, we were never asked to do everything. And you shouldn't feel like you're expected to do everything, even though the citizens sometimes have that expectation. They have a problem. Where are they going to go? They want to talk to their elected official, something like that. But recognize one of the most important risk management suggestions that I have is use your team effectively, your city attorney's office, your city manager's office, to help you manage risk and get good things done and look good while doing it, because they're here to support you. If an issue is coming up for which it feels like it's got a lot of hair and warts on it and it looks like it's going to be particularly problematic, they would love to hear about it early, right? So they can help you plan for that issue, help the body collectively, right? Understand what its options are, what the risks are, what the pros and cons are, whether this is a priority or not a priority. So I know sometimes there's a little bit of a tug out there in the community for citizens who think that it's your responsibility to address any issue that comes in front of you, but that's not the case. You're in good hands with your great team, so use them effectively. All right, let's talk. Let's go to the next slide. So some of you, if you've seen my presentation before, you've probably seen some version of this slide, but I'd like to put this up every time because I think it means different things depending on what you got going on and what lens you're looking at these concepts at any particular moment. So you all agree with this notion that when you become an elected or appointed official in the city of Woodland Park, right, your role and relationship to the community changes, right? kind of in a pretty dramatic way, right? In the eyes of the community, in the eyes of your constituents, you're no longer just a citizen. You're now an elected official, an appointed official. And I'm here to tell you from a certain perspective, that's a 24/7 job, right? Absolutely have a personal life and enjoy it, right? But whatever you think of it, fair or unfair, right or wrong, your constituents, the ones in the know, will always view you, right? As a member of the city council, as a representative of the council, as a representative of the city, right? And you know how that dynamic works. Maybe over this summer, you were out in the community at a community event, you're there with your family, thinking you're on personal time, and here comes a citizen they see over there. Hey, there's a council member. Let's go talk to him about city business. Is that city council member hat on? Sure it is. It was probably never off, right? And as is true, and as it should be, right? As elected or appointed officials, our words, our deeds, our conduct matters. It leaves an impression, certainly has an effect on people's lives if you're making decisions about people's property or adopting quality of life ordinances or making decisions on land use application. Yeah, so our words and deeds and actions matter. And sometimes, fair or unfair, if we have an interaction with a citizen and it doesn't go down the way they thought it should, right? Fair or unfair, that might leave a residue with them, right? It might impact your individual reputation as a council member or the reputation of the council as a whole or the organization. So it's worth keeping those things in mind. Knock on wood, absolutely true that not all of the concepts I'm discussing here necessarily and frequently point directly towards a liability claim, but they can in extreme circumstances. So keep those concepts in mind. Recognize also that part of the job for that elected or appointed official, right, as a member of a citizen, multi-member public body, is to be a good representative, a good ambassador of the organization. And in legal terms, you're a fiduciary, right? It says so right in the state statute, right? It says that public officials are fiduciaries, right? I quoted, let's go to the next slide. Right there in the state statute, I gave you a quote, right? It says the holding of public office or employment is a public trust created by the confidence which the electorate reposes in the integrity of local government officials. Fiduciaries, we all know intuitively what that means, but let me give you a definition a bit from a legal perspective. The fiduciary responsibility of local government elected and appointed officials is the obligation, right, to put the interest of the city, right, and the public interest above all other interests. That's the legal obligation, right? That requires sometimes, right, that we recognize some broader concepts. The fiduciary responsibility requires us to recognize the broader public interest, to put the city's interest and the public interest above narrow single interests, right, or personal interests. Do you ever have this dynamic? Let's see, we got a population of about 8,000 folks. Sometimes, not tonight, but maybe later tonight, I don't know. Sometimes the meeting room is packed and emotions are running pretty high, and it's a somewhat controversial issue. But even when that room's packed, we got a very small minority of our 8,000 residents, right? Yes, at that point in time, you're going to look out there and go, this is not going to be, I'm not going to make everybody happy tonight, whatever we decide, right? But it's the responsibility as the fiduciaries to think about sometimes, right, that silent but larger majority, right? And sometimes you'll have that dynamic unfold. Someone will stand up during public comment and they'll say, city council, you got to do this and you got to do it right now. The next person stands up and says, no, do exactly the opposite, right? In service of your fiduciary responsibility, right? One of your most important tools and powers in service of that role and in service of risk management, right, is to make sure that you as a council take the time you need and get the information you need to help you make decisions that serve your fiduciary responsibility, right? It's definitely the case that some of the risk issues, the claims issues that we deal with are challenges to decisions that in 2020 hindsight feel like those decisions were taken in haste, right? Or were taken on less than good information. So as a council and the planning commission as well, right? One of your most important tools and prerogatives is to take the time to understand the risks, the options, and get good information. That might frustrate some citizens who want you to do something that's a little off the dartboard and they want it done yesterday. But that's not your responsibility. The fiduciary responsibility is to serve the interest of the city as a whole. And then lastly, the fiduciary responsibility is to consider issues on their merits alone, no matter what that tug is, right? If it feels like This, somebody's trying to pull me and make a decision that I know is not serving, right, our fiduciary obligation to look after the interests and assets of the city. And that's an important reminder that you might be getting into risky territory. Let's go to the next slide. If you think about the fiduciary relationship, fiduciary responsibilities, we tend to sometimes think of it in terms of doctors, lawyers, other folks, right? But for local government elected officials, I think some of the components of the fiduciary responsibility still apply, but just in slightly different ways, right? We all think like a fiduciary has a duty of care, right? And in this context, the care of the interests and assets of the city, looking out for financial stewardship, right? Duty of impartiality, is that embedded in a local government? Right, oath of office? Yeah, particularly for quasi judicial matters, requires us to be fair and impartial neutrals standing in judgment of these applications. The duty of accountability, well, that's what the open meetings law and the open records law is all about, right? From your vantage point, looking down into the organization, that's what your responsibility is for overall oversight of the budget and the audit, right? Those kinds of things. Do you think the fiduciary responsibility includes the duty to preserve public trust in government?
Yes.
Right, I would think in terms of embracing that, right? After all, they sort of analogize municipal service to being on a train. On that track is that train, it's our community going wherever it wants to go. But during our particular term of office, we're on that train in the engine room, stoking that engine to help the community get where it wants to go, with the idea of leaving that engine stronger when we get off that train than when we found it, right? And I do think that's part of the fiduciary responsibility, right? Is to, maybe we got issues, maybe you got some discord among the group that needs attention, then it's a wise body that says, hey, part of our responsibility is to fix that for our organization so the institution of council is stronger and the city is stronger. Okay. And then lastly, wrapping up the fiduciary concept, again, we're each elected or appointed to contribute our individual voice, but to a larger discussion in view of what, right? Council and the planning commission, yes, they absolutely deliberate and discuss issues with many voices. And what's the point of having a multi-member local public body if we're not each contributing our own perspectives and viewpoints, but it's all towards working towards that one voice of the council. Sometimes it's articulated by a 4-3 vote. Other times it's by a universal thumbs up or head nod, right? But it's the old saw of deliberate with many voices, but speak with one voice. And that's how the council gets credibility and accountability to its voice. All right, let's go on to the next slide. I'm going to pivot and talk a little bit about transparency issues. You've all, have we got some folks who are brand new? Been at the dais a little bit, right? And our planning commissioners everybody's got a little bit of training on the open meetings law. So we know the basics of the open meetings law. Whenever 3 or more members want to discuss public business and ask a meeting open to the public. Just recognize that in our world, in the claims world, there is definitely I dare to say industry, I guess I can, the cottage industry, right? Of folks for whatever reason, and they have the right, not our business to inquire into their reasons, who are watchdogs of local governments, right? And they're watching closely whether they're in the room or not, whether we're complying with the procedural and substantive requirements of the open meetings law, right? And recognize that if they want to call you to account, right, they don't have to. Sometimes we think, well, they can't challenge our compliance with the open meetings law because they don't live here or they don't have a stake in the application. Our Court of Appeals, recently confirmed what we already knew as attorneys. And that is basically, anyone has standing to challenge your compliance with the open meetings law, right? And there's a cottage industry of folks that are located in any part of the state. And good thing because it shows your commitment to transparency, but they can read your minutes. They can listen to or watch the recordings of your meetings, and they analyze those things to make sure, right, you're complying with the open meetings law. So make sure you rely on staff on that issue. The main thing I want to point out is if you're going to have executive sessions, make sure you dot all the I's and cross all the T's, right? Make sure you follow appropriate agenda setting procedures and all that kind of thing. Don't have surprises with the agenda, and right? We don't want to show up last minute and add things to the agenda, that kind of stuff. So in the risk world, the two things going on is a lot of people, anyone has standing. So we see people bringing suit. The claimant may be located down in the southwest corner of the state, but they're filing a suit against someone up here, right? And then second is if we get into court, the courts are inclined, the rules of construction require the courts, right, to construe the open meetings law in favor of openness, right? So that's going to mean we got our foot in the bucket in terms of the legal standards in defending something that might have been up to or stepping over the line. So be careful on those issues. All right, let's go to the next slide.
Hey, Sam,
Yes.
so when you say anybody, is that anybody in Colorado or anybody in the world or that has standing?
I'm not sure we've had a claim with someone out of state, but definitely anyone in the state.
Okay.
Yeah. Okay, let's talk about electronic communications. Do you all use email to do your job as an elected official? Yeah, do you have city issued email addresses?
Yes,
Planning commissioners, do you use your own email address? Or you have city?
they have city.
City.
You
Okay.
don't have city?
You should.
Oh, okay. All right. Well, whatever it is, just remember this background principle, the open meetings law, basically, excuse me, independent of the open meetings issue. The Colorado Open Records Act basically says that the correspondence, right, of public officials is a matter of public record. There are some exceptions that if you ever get a open records request, right, the clerk's office and the attorney's office will help analyze which documents have to be disclosed, which ones have to be withheld, and which ones are on the margin. But it suggests this risk management principle. Recognize that whether it's an email, a text, a chat message, social media that we'll talk about in a minute, any of those things, right? If you're sending or receiving that communication wearing your hat as a local government official, then that communication is potentially subject, right, to disclosure under the open records laws to anyone, right? Certainly wouldn't, including people you may not have had in mind when you sent that message, right? Yeah. So that's an important piece of that, right? Just recognize that all forms of electronic communication could be subject to the open records law, and they can also trigger the open meetings requirement, right? If 3 or more members are using email to discuss public business, having an email chat about the merits or substance of some pending city business, that's also a no-no under the open meetings law. Because why? Because that discussion's not open, right? So that's why staff's trained you up on, hey, don't hit reply all, right? And if you're wondering, well, why can't I reply all? The good thing to start with is contact the manager, right? Or send just an email from yourself to the manager, and then he can look at all these responses that he's receiving individually from council members and understand whether this is an issue that can be resolved with a one-off conversation or something that needs to go in front of the full body. Okay. Now, Cora is one thing. I will tell you, in my world, in the claims world, it's all about electronic communications, right? Because all the claimants know where they can find the packet and the staff memo and the decision document. What they really want to know is, was there any discussion among the elected appointed officials by electronic means about this issue that I'm concerned about, right? So in litigation, it's all about electronic discovery, which is a much broader net. Things that could be withheld from disclosure in the face of a Cora request may nonetheless have to be disclosed in litigation. And believe you me, you never want to be the person, right, who's listed as one of the potential defendants in a lawsuit, either in your individual or personal capacity, where your name is attached to a zinger, right, that creates some potential liability for you. So the whole takeaway on all this is just remember that public officials, you need to be circumspect in your use of electronic communications. I would suggest wearing that public official hat. Don't say anything in an email, text, or chat that you wouldn't want to say in an open public meeting, right? Or that you wouldn't want to read in the newspaper or have read back to you in a deposition. So those are just kind of some takeaway concepts on that. Okay, let's go on the next slide. Let's see. Does anybody use social media to do their job as an elected or appointed city official? No, so social media is in the news a lot, and those are headlines that we clipped on that issue. Let's go to the next slide. In our elected officials handbook, we have a chapter about things that at the governing body level would be good to have on your risk radar, and same thing for the planning commissioners. Do you have, any of us have personal, we're active on personal social media, that kind of thing? Just remember that there are concepts that are discussed a little bit in here, that with social media, I think people who are on social media, when they know that you're an elected appointed official, from their perspective, the hat is never off, right? The hat is never off, right? There's all sorts of legal issues around those issues, but at the end of the day, in terms of perceptions, right? People who know that you're an elected appointed official and they're reading social media activity, they're always going to view you as an elected or appointed official for the city. Some of the issues to think about from a risk or legal compliance standpoint is if 3 or more elected or appointed officials are using social media to discuss pending public business before the city, same open meetings problem attaches in my view, okay? There's open questions on these issues because the wheels of litigation moves more slowly, but there's still the same question of, if I post something on social media wearing my city official hat, is it a public record? What do you think? Yeah.
Yeah.
Right. The means of communicating is not the criteria for whether or not we decide something is a public record. It's the content of the communication. So there might be open record issues as well. There's First Amendment concerns, right? Running both directions, right? The hot topic in the news a couple of years ago, and it's still a hot topic, is can elected or appointed officials block, right, or delete comments from citizens who are jumping on the elected or appointed official social media thread? And the short answer is, if you're going to get on social media, right, I think you either have the comment thing turned on and you leave it on and just recognize that that's the rough and tumble world of social media, or you have the comment feature turned completely off. But don't flip the switch on and off. Don't try to block the voices that you don't like while retweeting the ones that you do like. That's all just going to suggest if you're wearing if the claimant is successful in demonstrating that you were wearing your public official hat at the time, that's just going to all be fodder for a First Amendment claim. Okay. Social media, I don't know what, do you have something like Nextdoor up here or these? Sometimes there's a lot of buzz about quasi judicial applications, right? And you might be looking at social media and you see this post of somebody post, hey, big land use application coming up next week in front of the planning commission. And you start reading that and you go, wait a second, everything they're saying there is wrong about this application. You want to stay away from that. You have a great forum and a great venue for discussion of quasi judicial matters. And there's only one place to do that, and that's here, right? And from a due process standpoint, you need to disengage from any of that social media buzz around quasi judicial proceedings. I'll mention that a little bit more in a moment. Okay. Other legal risks is to recognize that social media, if you're not, well, I guess it's true whether you're wearing your public official hat or not, the same risks for tort liabilities exist on social media as they do for any spoken word, things like a risk of defaming someone or copyright infringement or public disclosure of private facts, right? Any of those things going on. Someone who gets their back up and thinks they have a legal claim around those issues can bring that claim. Okay. Last thing I want to mention on the risk side, do you agree with this notion that sometimes elected or appointed officials can be on the receiving end of less than courteous social media commentary? All right. Yeah. Just, I would encourage you to recognize that if you're on social media, that's just the rough and tumble world of social media, right? And a lot of that, the overwhelming majority of it, is protected First Amendment speech. And so if we're going to get on there, right, and read that stuff, we have to recognize that as local government officials, we're state actors for First Amendment purposes. I don't know how we got to it in this world, but sometimes people on social media, or even like maybe during your public comment periods live, are going to come up and say something to try and push your button, to get a reaction in hopes that you, either individually, collectively, wearing your public official hat, are going to do something that they think violates their First Amendment rights. Strange world we live in, right? But do recognize that a lot of that stuff is protected speech. Now, having said that, if there is something going on social media that gives you concern for your own safety or the safety of your family, right? Don't gainsay the perceptions of your own safety, but do get resources. Reach out to your city manager, city attorney first. They can take a look at that, right? If law enforcement needs to get involved, they can take a look at it. It may be they look at all this and go, yeah, this stinks. This is, jerkish behavior, but
it's basically not a true threat. It's hyperbole or something like that, for which you really can't do anything about other than just say, well, I'm going to take solace in this. Last time I checked, when I looked up these stats, I think there's more than 600 billion social media posts a day. Yeah. So, what seems like something we got to deal with and respond to right now, right? That's going to be yesterday's news before the end of today. So we just have to have a thick skin for that stuff and let that roll off. Okay. On the legal side, just so you know, there are some new laws that our legislature has passed in the last 2 or 3 years that do protect public entities. Not always public officials, but things like officers, election officials, other folks from doxing. And that's publishing on social media private information about a public official or public employee. If you ever think that's going on, make sure you get in touch with your manager and attorney, and they can give you more information on that issue. Okay. Let's see. Let's go to the next slide. So getting away from the risk and legal stuff on social media, we do have a chapter in the handbook about that. Here's some tips I would suggest around social media. If you are there and it's your personal account, make sure your personal social media account is labeled as personal, right? That's going to protect you somewhat from this First Amendment risk on the legal side. It's not going to protect you necessarily from the risk that the perception out there is this is still, right, a city official speaking, right? And so you got to decide if you want to live with that perception and the impacts that it might have in the two worlds kind of overlap a little bit in that regard, right? And does our personal social media activity have impacts that are affecting my effectiveness or reputation as a council member or us as a council? That's not necessarily a civil liability risk, but it's an impact. Don't engage in discussion of quasi-judicial matters on social media, right? That can create a due process problem. I'll stick my neck out a bit, I think. I would suggest that social media is not the best vehicle for adjudication of the lofty and important public policy issues that you deal with as a council, right? That's what your council meetings are, right? So I do think social media is a great tool for re-emphasizing and retweeting and pushing out their messages about the great things that you're doing as a council and as an organization. Right, but you know how it goes. You might even put out like something on social media that says, hey, come to our great event this Saturday down at the park right next door here. And the first thing you get in the thread, well, you're all crooks and liars and you stink, right? What are we going to do about that? That's their opinion, right? But we're just going to move on. I wouldn't let the tail wag the dog. I'd still use social media if you use it, your official channels for, and your personal channels for sending that, helping to calibrate public attitudes about all the great things that you do. That's what I think social media is a good thing for. If we're providing personal opinions on social media, are our personal opinions denoted as such? Do you agree with this notion as well? We're all in this world today, we're all just content, information. You feel like sometimes like the pressure on you as elected officials is your constituents want to know, right, tomorrow's news yesterday, right? Yeah. So recognize that dynamic is particularly at play with regard to inquiries from the media and social media traffic, right? Where council might be here in a process, but everybody on social media is wondering where you're going and they're speculating as to where you're going. So I think one of the dynamics for a council or a local public body collectively in terms of its institution of council is, are we attuned to the idea, even if we want to engage on social media, are we attuned to whether our social media post is something that might be getting ahead of council or purporting to speak for council before council has yet had the chance to articulate its own voice? Now, sometimes elected officials will call me about that issue because they're wondering whether there's a state statute or some rule that's an easy answer to that, right? But the way it really, and the answer is no. You can ask Jeff, maybe he's found a secret on that. But it's more like supporting the institutional council and supporting each other. The way the frustration is expressed to me is sometimes an elected official will say, look, I was looking for whether there's a rule or guideline on this, because what happens in some of our meetings is we have a new policy issue on the agenda for the first time. At least I thought it was the first time, but now we have, one or more of our members who are kind of out there on social media or through email, and what they're saying is being perceived to be the voice of council before we as council have even had a chance to speak. So now I feel like I'm coming to policy discussion with one foot in a bucket, because all the citizens believe like the council's already headed this direction, right? And we as council haven't even had a chance to talk about it yet. That's kind of how the dynamic plays out. Okay, the First Amendment issues are there. They're discussed in the handbook. The US Supreme Court, you probably read, did recently heighten, that's a good thing, did heighten the standard for First Amendment liability for blocking or deleting comments, but my advice remains the same. Unless it's a true threat or pornographic obscenity, right? Or something that's inciting a riot, then we just have to let that stuff go and recognize that that may be somebody who's just trying to bait us into a First Amendment fight if they're getting on our public official social media activity and trying to bait us into something. Okay, last thing on social media, remember that example about the planning commission and the hearing coming up? And you see all that and it's like, this is all disinformation about the city. You want to think critically about, should we be jumping into that? Right? Particularly on social media, right? If people are going to have and always embrace their own view, is there anything we can do on social media that's going to change those views? Or are we just going to get thumbs up for the people who like our thoughts and thumbs down from everybody else, right? So I would, in terms of protecting yourselves from risk, and particularly for quasi-judicial decisions, you can't and should not jump into that fray. But if it's something where there is a lot of disinformation, maybe the management staff's already attuned to that, and maybe they ought to say, or maybe we decide, hey, with regard to this very controversial land use application, let's just put up on our website a very prominent link to the planning department where they can click on that, and then they can learn, those who do want to learn, those who don't, that's fine. They can click and learn the actual factual information that the city has about that. And then you can just tell persons, hey, I don't get involved in all that stuff on social media because I'm the judge in that application. But if you want to learn about the application, you can go to our website and there's factual information about that issue. Sometimes that's a good tool to take the heat off all of you, right? Because sometimes people say, why didn't you email me back? Or why didn't you respond? That kind of thing. Yeah. Any questions, thoughts on transparency related risks? All right, let's pivot and talk about organizational structure. Next slide. As I mentioned at the outset, organizational structure is very important. Everyone within a municipal organization has a job description, right? That's true whether you're elected, appointed, an employee, or even a volunteer, and it directly influences risk for everyone in the organization, both collectively and individually. So the good news is, right,
If you ask Jeff, I'm sure Jeff very deftly handled the question, but I hope it wasn't your first question. You say to Jeff, can I get sued and can I be held personally liable as a public official in Colorado for something I do or don't do, right? And the answer, of course, is yes, that's possible, right? But the good news is we have real strong protections for you, right? And they work this way. We have a statute called the Colorado Governmental Immunity Act that basically says the city, and by extension, its insurer, CIRSA, will defend you and pay judgments entered against you for acts or omissions as a public official. Good news. We're protected. But there's a catch to that, like like most things. Those protections apply, right? Statute expressly says those protections apply only so long as we are acting within the scope of our employment and not acting in a willful and wanton manner. So the two phrases that seem odd to a volunteer part-time citizen appointed or elected officials, what do you mean scope of employment? I'm not an employee like the full-time manager or the full-time clerk. It had nothing to do with me. Yes, it does, right? Simply means scope of employment is the phrase that's used in that liability statute. Simply means everyone must know and understand and stay within their particular duties, responsibilities, and authority, and not stray from that and try to exercise duties or authority that we don't have, okay? So I'll give you some examples of that within our own organizational structure here in the city. Within the City of Woodland Parks organizational structure, within whose job description, within whose scope of employment is it to make that initial decision of whether someone gets a short-term rental permit. Who would that be? Is that you, Aaron? Or the planning director? The planning director? Okay, so within whose scope of employment ain't it? Yeah, everybody else, within whose scope of employment, within whose job duties is it to decide whether or not someone with a building project going on either gets a building permit or gets their building permit revoked because they're not complying with the building code. Your chief building official, right? And no one else, right? So, and this concept of allocation of responsibility and duties, job description permeates the organization. On the other hand, within whose scope of employment, within whose job description was it to determine in the first case whether we even have a policy or ordinance on short-term rentals? The council. All right. So that's a very important piece to remember. Keep that in mind. It's as important not only to understand what our own job description is as defined by our charter, our ordinances, state statute, but also to understand what duties are given away or assigned either by the council itself or by statute or by the charter to others in the organization, whether it's the clerk, the treasurer, chief of police, the election official, whatever it may be, right? Those are important concepts. All right, the other one is you're protected as long as you're not engaging in willful and wanton conduct, which sounds kind of ominous. I've given you a definition there on the slide. The way I describe it is essentially this: it's conduct that's intentionally undertaken, that's designed to injure someone's protected rights, and that's taken with reckless disregard for what their rights are. And my even shorter way of describing it is I just call it bad stuff. And we all know what it is. We're all going to stay far away from it, but it happens. Knock on wood. Every year we get a couple of claims where the claimant alleges that some elected or appointed official or employee engaged in willful and wanton conduct, and I, as the claimant, want to hold them individually and personally responsible. Our claims people usually, I ask them, what are the circumstances under which these claims typically arise? And it's almost always this. It's almost always an elected or appointed official or employee, right, misacting individually, misperceiving that they have some governmental authority that they actually don't have, right? Throwing on that purported cloak of governmental authority and going around and doing bad things to people for the wrong reasons. And it really would be bad stuff. To use my other scope of employment examples, it would be like, for example, conscripting the chief building official into the desire to make sure that the business competitor, right, doesn't get their building permit for no good reason, right? Or defaming someone with, making false statements about them with, actual knowledge that the statements were false with intent to injure them, right? Or attempting under a cloak of governmental authority to attempt to interfere with someone's prospective business advantage or with their existing business relationships. That all malicious conduct, obviously criminal conduct, right? We all know that's bad stuff and we're going to stay far away from it, but needed to point out the contours because a finding of willful and wanton conduct is one where the employer, the city, has no obligation to defend or indemnify the elected or appointed official in that circumstance. Let's go to the next slide. That same concept ties to your public entity insurance coverage, right? Public officials liability coverage follows the same concepts, right? And you've got great protections through CIRSA, but like every public official's liability coverage, it provides coverage against alleged wrongful acts, but it's got exclusions. The coverage attaches, it basically says, we will provide coverage for elected officials in their capacity as such, right? Or we provide insurance coverage for them in the discharge of their duties while acting within the scope of their duties, right? But willful and wanton conduct is not within the scope of duties, right? That's why that point of attachment is so critical. And the insurance coverage document has exclusions when the liability, if it was actually found or determined that the liability arose because of willful and wanton conduct or criminal conduct or fraud or ill-gotten gain or malicious acts, then those protections fall away. There's no obligation for the employer to indemnify or defend, and there's no coverage under the insurance policy. Okay. So that's the explanation of the state protections. Okay. you want real live examples of willful and wanton conduct claims we have, and I'm not gonna name names, other than to say it doesn't involve anybody here. But we've had claims, for example, where, a citizen has filed a defamation suit against a sitting elected official for defamation, right? We've had business owners or property owners allege willful and wanton conduct against an employee or elected official or alleged interference with their business relationships, right? Attempting to use the cloak of governmental authority to direct or influence that they not get a license or a permit, that kind of thing. So we've had those situations, but we all know where bad stuff is and we're going to stay far away from it. Okay, so that was the explanation of the state protections and the exceptions. Of course, we got this whole other area of liability risk, and that's under federal law, right? And like civil rights claims under federal law, right? We hear about those. You have a nice form of protection there at the federal level too, as a protection against federal claims. That's qualified immunity. We hear a lot about it around policing, but qualified immunity is a concept that applies to all public officials, right? And it basically says this, it says you're shielded from individual personal liability as an elected or appointed official, right? Right. So long as your conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. I think the most fascinating phrase in that is the would have known. And you're thinking, wait a second, I'm a part-time citizen volunteer, elected or appointed official. How do I know? That's where it all ties together in my mind, reaching back earlier into my presentation. If you feel, right, you someone, please, I hope you never face this dynamic, but somebody standing up in a meeting and says that if planning commissioners, if you deny this application, I'm going to sue each and every one of you individually for civil rights violation, right? That's the time we go, okay, wait a second, time out. We're going to take some time here and get good information and take the time and get the information we need to understand the risks, right? Alternative pros and cons and legal liability contours around this area. And that's where your great team, the city attorney's office, is going to help you, right? To understand that issue, because it's absolutely the case that, yeah, you can be liable. There is such a good thing as, there is such a concept as you can make a good faith but mistaken decision or take a good faith but mistaken action that can expose you to civil rights liability. That's what the insurance is to protect you against. But on the other hand, if we knew it was improper and we knew that the law was clearly established that, for example, we can't direct the chief of police to remove someone from the public comment period just because we didn't like their opinion. Well, yeah, that's clearly established law. We know that would be a violation of their First Amendment rights. It gets a little more nuanced. A lot of interesting and thorny issues that you deal with, right? Everything from what's the constitutionality of short-term rental regulations? What's the constitutionality of, what else? Jeff, what are you dealing with? Probably not oil and gas.
Assuming the debt of another public entity is violation of Article 11.
Yeah, yeah, yeah. Right. Yeah, things like that. So if those are if those kinds of risks under federal law, civil rights law, federal employment laws, equal protection, due process, if those are raising their head, then use your city attorney's office as a resource to help you understand what your risks are and keep yourselves in a good, safe space. Okay. All right. Let's go on to the next slide. Reaching back and talking about kind of basics of organizational structure, you know this, but a key component to understanding risk and the protections and where we should be is to understand the legislative administrative distinction that's established in your charter and in your city code. You have through your charter, right, and through your organizational structure, that form of government where we're a council manager form of government, which is a wonderful thing. You've invested a lot of resources in that. Your voters chose that under the charter. Use it to your advantage, but it really does mean, right, that there is a distinction between the policymaking arm of the organization, the council, and the administration. It's not that we're silos. We're all working together to keep that train moving forward. But from a risk standpoint, it does mean there's definitely an allocation of duties that's centered around the policy versus administration distinction. The council, right, pursuant to your charter, is the legislative and governing body of the organization, right? The mayor is the presiding officer, gets to be the presiding officer and gets to sign all the papers and do all the ceremonial stuff. And then the manager under your charter is the administrative head of government responsible for day-to-day municipal operations. So you want to appreciate and honor that distinction and use it to your advantage. Just remember that by statute, charter, or ordinance, right, all of that serves to not only define the different duties between the policymakers and the governing body and the administration, it defines scope of employment from a risk perspective, as my early examples pointed out. Let's go to the next slide. Another way to look at this is to look at the kind of concept of where does the governing body at the top of the organizational pyramid, where does the governing body focus its efforts, right? On the left-hand side of the slide, kind of tiers of operations within a municipal structure, right? Where does the governing body spend its energy? Right? Who are the owners of our municipal corporation? Yeah, yeah. So I would commend to you that the governing body, right, is that part of the organization that's uniquely spending its time in the top two tiers, right? It's the part of the organization that's helping define the needs and wants of the community, right? You have provide a place in a forum where citizens come to you and tell you what are our needs, desires, wants, and then you're uniquely situated as only only seven folks, right? Have that power to help determine at a policy level how we put governmental resources on those needs and wants, right? So you're responsible for the legislative affairs of the organization, right? Setting policy, adopting ordinances on whatever the subject it may be. I think in terms of time horizons, that means that council is the part of the organization that has the longest time horizon, tying that back to the policy versus administration distinction. I think that means the important issues and documents for the governing body are those long-term things, the annual budget, the comprehensive and master plan that you work on with the planning commission, the capital plan, thinking about where do we want the community to be in 3, 5, 7 years, thinking about legislative policy setting, and then of course dealing with the corporate and quasi-judicial matters that are reserved to the council. For example, do you have purchasing policies? Yeah, and by that that's yet another example of scope of employment or delegation of authority is another way of putting it. You probably define, hey, at below this level, if it's in the budget, it's already appropriated and there's an expenditure, I don't know what your level is, but if it's below that purchasing threshold, then it's the manager's responsibility, then we don't want that as a council. That's his responsibility. But above that, right, it comes to council, and certain types of decisions are also reserved in council. Maybe you probably decide whether or not to buy or sell property, right? So those kinds of things are reserved to council. We'll talk about this in a minute. I think that also means within that policy administration distinction in dealing with the chain of command, your resource, your point of contact, I analogize it to the private sector corporation where the board, you're fortunate to have in your governance structure, that relationship of board to CEO. We just happen to call it city council, city manager, right? And that's your point of contact. That's your point of accountability in terms of the chain of command. You don't want to jump over, right? You don't want to go more than one level down the chain of command. We'll talk more about what that looks like in a minute. And then the last thing in terms of where we spend our energy is remember, like if you have a vacancy in a department head, well, I think it's always possible that the manager can appoint an interim department head to take care of that, right? But if we're not honoring the organizational structure that we have, and we are overly involved as elected or appointed officials in administrative matters, then we have to ask ourselves who's watching the farm in terms of governance and legislative and policy making, right? There's no redundancy at the city council level. We can't appoint an interim council, right? So that's why I commend to you that your focus, your energy is spent in those top two tiers. All right, let's go to the next slide. In terms of actual risk management, here's a couple of ways to look at these issues, some tips around this. Understand the job description. Good way to look at that from an individual perspective is to recognize that when you get elected, do they still, Suzanne, do you still get a hard copy of the ordinances? I'm dating myself here, but it used to be.
I offer them up to them, but they all want them digital.
Okay, yeah. I'm dating myself here, but it used to be.
These are,
Yeah, back in the day, it used to be you take your oath of office and your family's all there, and the next thing is the clerk will give you this book of 1,000 pages, right? Of all the ordinances, that stuff is still there, right? That stuff is still there, but you want to make sure we understand what all those ordinances provide in terms of who has which authority. But remember for the city council, the council in all those hundreds of pages of ordinances, I'm pretty sure you will not find a single provision that says the power of the city council may be exercised by one councilman. It's a collective power, right? So in terms of risk management, there can be, unfortunately, sometimes this mistaken view that, hey, I'm a member of the city council and I'm one of the 7 members, so, I must own 1/7 of the power and I'm gonna go out and use it. It doesn't work that way. It's a collective power. In fact, the open meetings law says that the power of the council can only be exercised, can only take decisions, take action in a duly noticed public meeting where all the council members or a quorum is present and they're acting collectively. So it is a big risk issue, right? If we're thinking in terms of I instead of we. I know that can be frustrating at an individual level. We'll talk more about that in a minute. But if you find yourself thinking in terms of I, you have to ask yourself, do I really have authority to act? And if not, then don't do it. And better pivot it and say, this is a we. I want to collaborate with my fellow elected officials and get this done. And that's how I get power in that regard. Okay. Recognize that elected and appointed officials act primarily as a body. Yes, you do have ambassador roles within the community, right? But you act primarily as a body and primarily exercise your responsibilities by meeting and voting on items in a public meeting. Same thing with the planning commission. I'll identify one other risk for you here. Mayor, do you have during your meetings, maybe it's at the end or beginning of the meetings, you have an opportunity for council member reports? So this may never translate into a third-party liability risk, but sometimes the dynamic is mayor calls, hey, everyone, great meeting. Before we adjourn, are there any council member comments? They say, yes, Mayor, I've got a comment. I got something to report. Since our last meeting, I did this. And everyone's eyebrows go up. Right? That's a risk, right? It may not be a third-party liability risk, but that's a risk for the council as an institution, right? I think it's a wise council that has that discussion around what are our expectations, norms of conduct, on how we conduct ourselves and how we represent the council and the city in between meetings. I say it because, not too many of them, but I say it because people have submitted claims to us, right? For alleged improper conduct by fellow elected or appointed officials in between meetings. I hope it never gets to that point because I would prefer that everyone feels supported. You're all busy enough doing what you do here now, but sometimes you raise your hand for yet other stuff. Like maybe the mayor is the typical point of contact to go talk to the county. Somebody say, hey, I can't make it to that meeting. Can somebody else go? Right? Oh, I'll go. We go over to the county and then we purportedly represent a position. Where the county says, hey, I know it's supposed to be just a discussion item, but we got to sign this letter to the governor and I need to know City of Woodland Park's position right now. So single council member, what's the city's position? Those are all risk issues for you, right? Particularly reputational, right? And so you want to think about what that looks like. Don't allow some other entity or some other group's crisis in between meetings, right, become your problem. If you need time as a council, because you haven't talked about what their ask is, right, then be selfish in protecting yourselves and the institution of council by bringing that back to the group, right? So that's an important piece as well. Okay, let's keep going. Okay. Supporting organizational structure is also particularly important in the area of employee relationships and in the handling of administrative matters assigned to staff that I've already hinted at. So in our organizational structure, about how many employees do we have? 105. How many of the employees are directly supervised by the city council? Three, and the planning commission?
Just one.
Probably 0. You probably have a staff liaison.
It's only Aaron. Yeah.
Yeah, right. So that's almost uniform across the board, particularly for home rule municipalities, where the 3 positions that are supervised directly by the city council are limited to the judge, the attorney, and the manager. I will tell you from an employment practices risk perspective, what a great place to be. Because what that allows you to do is rely upon your charter and ordinances that basically say that supervision of the remaining 104 employees is vested in the manager and supervisor below the manager, right? And you can say in the face of some employment practices issue, that is not our issue, right? And so that organizational structure protects you, right, as elected officials. Because it, on the ballot, it said elected official, it said policymaker, legislator, never said HR manager, except with respect to your manager, right? So, but it's going to be the case. I'm not naive. Before I joined CIRSA, I did what Jeff did for 25 years. And I'm not naive around these issues. Pressure might come from inside or outside the organization. Maybe a citizen who's unhappy comes up to you and says, hey, I want you to do something as a council about that employee. Is that your job? Not your job, right? And I will tell you that employment practices liability risk in this world, this day and age, is like as pervasive as the air we breathe. Right? So you want to use your manager as a resource. Something, yes, I get it from a citizen's perspective, or maybe it even comes from inside. Maybe a frustrated employee comes up to you as a council member, hey, can I talk to you about my boss? You know, maybe the response needs to be, well, hey, look, we love and appreciate our employees, but I as a council member and we as council don't get involved in personnel issues, right? That's for the city manager. I encourage you to talk to your supervisor, the HR department, the department head, whatever it is, someone who can help you with your issue. Now, we recognize that there are sometimes personnel issues that have a lot of hair and warts on them, and that's what CIRSA deals with. And so sometimes it is going to be the case, there's going to be a personal issue that's got enough hair and warts on it, but the manager is going to give you a heads up. Right? My classic, although somewhat humorous and a little bit facetious example is maybe he's got a department head, you know, and the FBI contacted him today and said, hey, I just want to give you all a heads up. The FBI is going to be by the city tomorrow to arrest one of your department heads on a felony warrant. That's probably going to be interesting news to the news media, right? So the manager is going to give you a heads up on that because you don't want surprises, right? And you want to hear it first from your team, not from some citizen or from the news media. But recognize that he's giving you that heads up, not to say that you're all the supervisors of this department, but to help coordinate the message. And to also give you the heads up that if you have any questions, right, or if the media contacts you, then who's our point of contact? And then gives you the resource to make sure you unburden yourself, right, of involvement in that personnel matter by directing it back to the manager. It's absolutely the case that sometimes people will try to conscript an elected or appointed official into a personnel matter. And if it blows up into litigation, then we have to interview witnesses or have their deposition taken. And I'm pretty sure I've never had an elected or appointed official that got ensnared in a personnel matter ever come back to me after we had to set up their deposition and say to me, that was a lot of fun, let's do it again. No, absolutely. The system is set up to protect you, to make sure personnel issues are attended to by the professional staff, to protect you from all sorts of risk, retaliation, or even being a direct target of someone claiming that you were harassing them, and you were discriminating against them. So you want to unburden yourself of that and make sure you let that staff go and put it in the manager's parking lot. Okay. Same thing with administrative matters. I think we've touched on this previously. Oh, I did want to mention that some of the concepts about employee relationships, that's enshrined directly in your charter. I mentioned the section there. Section 4.4 basically says neither the mayor nor the council shall dictate the appointment or duties of any officer or employee of the city, except essentially for the manager or the judge or the attorney, nor shall the mayor or any elected official prevent any officer or employee from exercising their judgment and performing their duties, and except for the purposes of inquiry, you shall deal with administrative matters solely through the manager. So again, it's not that we're silos, and it's not that elected officials aren't, entitled to ask about administrative questions, but you want to make sure you have good processes and procedures in place to do that, to help ensure the organization's firing on our cylinders and that you're not getting crosswise with some of these principles that unfortunately could lead you into some risk areas. Okay. Let's see. Do be cognizant of we're still a small and collegial and friendly organization. Do remember in the perception, it says except for the case of inquiry, right? And so we're friendly with staff and we're gonna say hi to staff, but remember perceptions if you're interacting with staff below the level of the manager, right? What you say and might think is a kind of an innocent, hey, what are you doing? I'd like to see this happen. They might perceive that as a directive, right? So if you have those thoughts and you want to see something happen, who are you calling?
Goes. I said the same.
Yeah, right. All right, let's go to the next slide. Ghostbusters.
Said the same thing.
Some practical tips on that. That's, having whatever it looks like to you, there's no one size fits all to this. Excuse me. But establish a process for bringing forward questions and concerns about administrative matters, whether those are your own concerns or questions that have been raised by a citizen who approached you, right? Or an email that you got, you get a fair amount of emails from citizens. Yeah, probably the mayor more than most, right?
Calls.
But you
Yeah.
might get a phone call and, you recognize, hey, this is not my issue, but you can still, as an ambassador of the organization, you let that constituent know, hey, that's not something that I'm involved with, but I'll give you the contact information of the manager. He chases down the answer from whatever department, gets back in touch by whatever means with that citizen. And then in your ambassador role, you can still close that loop. Next time you see that citizen, hey, do we, as an organization, get you what you need, right? And there's no one size fits all. Some communities have complaint forms or citizen inquiry forms or request forms. Some just say, hey, go see our manager or go see the department head, whatever that looks like. Be cautious of this as well, particularly on the high profile issues. Sometimes you're gonna, maybe short-term rentals was a controversial topic.
Oh, no, not at all.
That's a piece of cake.
But remember, you probably did all that work as council, right? To get that in place and set policy. There's still gonna be people who are probably unhappy with the policy, right? You want to be careful of those efforts, and you may even, let's say it was a split vote on the ordinance, right? And you may be one of the people who voted against it, so you're like, well, I'm not happy with the policy, but I recognize it's the policy that the city council adopted. Sometimes people might be trying to conscript you into doing an end run around a policy that you just adopted, right? So you want to be careful of that and make sure you're supporting the organization as a whole and making sure that citizens understand that if there's a policy or ordinance or administrative rule that they don't like, it's not the council member's role or the appointment official's role to facilitate an end run, right? It just makes us weaker as an organization, undermines the credibility of the policies that you all just put in place, right? That's it. With regard to your own direct reports, how are we doing, Tom? Good. With regard to your direct reports, your manager, your attorney, your judge, you're going to have whatever that system looks like to you, but hopefully, have mutually agreed upon and respectful systems for giving feedback, giving direction, evaluating performance. Do recognize that though we have 7 members, it's not 7 bosses, right? It's a group, it's one boss that has 7 members, right? And so it's the responsibility of the council to resolve its own differences of opinion on what the direction ought to be to our direct reports. And need to be careful of that issue, I would suggest, because I've seen it back when I was in Jeff's shoes. I would see it, here's how it kind of unfolds in real time. We have one of those discussions. Mayor says, hey, great discussion, council. This agenda item, we need to give some direction to our manager. What's the direction? We go down the dais, get one idea of direction, another idea of direction. Before we know it, we got these 7 different ideas of what the direction ought to be to the manager. And that's when we turn to the manager and say, Aaron, you got your direction? Absolutely. You look at our watch, and go, geez, what time is it? Yes, I've got my direction. That may be true, right? But it may not be, right? But who owns that issue? The council does. Council's the boss. You want to own that issue, but you have to commit, right? And one of the things that the mayors do, among the other dark arts that they practice wonderfully, right, is the mayors
Can't wait to hear
that
that.
dais and say, well, this is intractable this evening. We're not going to get there, but we're going to bring it back. As a council, we're going to bring it back to a work session or another meeting. And we as a council are going to talk through, fight it out, debate it out, whatever it is. And even if we have to put it to a vote, and even if it's split vote, we're going to make sure we give clear direction to our manager, because that's where we get clarity as to what our direction is. That's where we get accountability. Right? And I've seen it happen back when I was at city and town attorney, seen it happen so many times where it breaks down, and then we get recriminations and erosion of trust, because what can happen is if we don't commit to do that, what can happen? You know, maybe later in the week, people start dropping by the manager's office. And they say, you know, an individual one-on-one, hey, that was a messy discussion the other night, but here's what I want you to do. Is that consistent with the voice of we, the council? Would you be frustrated as a council member if a council member with exactly the opposite view of yours were doing the same thing? How do we get back together on that issue? How do we build that trust? So that's an important dynamic around that issue. Okay. Let's pivot now and talk about my last substantive topic. Any questions or thoughts you want to share? Things I haven't covered on that administrative policy piece? On quasi judicial matters, there's another just fascinating thing about local government. That's why we all love local government so much. We do so many things that directly, right, help and impact our community, and we have local control, right, Governor Polis? Yes. we have-
I was gonna
we
say,
have a local control, right?
we're trying.
Colorado, by law and tradition, regulation of land use has long been a matter of local control. Right? Same thing with licensing. Do you do the liquor licensing? You have marijuana. You do the liquor licensing. Right? Does council handle any other licensing issues? Just land use, things like subdivision, zoning requests, planning commission has a role in the process, and then liquor licensing requests.
National medicine.
So.
Someone has a question.
As
Jeff,
well.
is that
I
you,
just
Jeff?
was pointing out natural medicine is another thing that would fall under our licensing control.
Okay, and council's gonna be the licensing authority for that?
Yes. No, we're not.
No,
Okay,
no, I think
sorry,
you
I'm
have some
wrong.
zoning authority, but otherwise the licensing is at the state level, right?
Yes,
Yeah,
that's right.
okay.
Thank you, Aaron.
So that's fascinating because a lot of the time as the council, you do legislative things, policy making, or you deal with corporate matters like contracts, intergovernmental agreements, buying and selling property, intergovernmental relationships. But other times, both the council and the planning commission are making decisions that affect individual applicants. And at that point in time, we're making decisions that affect their individual protected property interests. And we didn't see the distinction right away. Like if we're just doing a general update to the subdivision regulations, there's no specific applicant in front of it. We're just making general rules that apply to everybody, no one in particular. But when we have a subdivision application in front of us, of a specific applicant, specific landowner, specific piece of property. And at that point, the Constitution recognizes that we're now making decisions that affect the individual constitutionally protected rights of that applicant. What an awesome power, right? 7-member planning commission.
Yes, is it,
7-member.
when
Wow.
it's, yeah.
Up
when
to
it's-
9, yeah. So among in a community of 8,000 folks, right? You got no more than 16 people who have the power to decide whether someone gets their subdivision approved or not, gets their rezoning approved or not. And we want that control. We don't want the county making those decisions or the state making those decisions. But the grand bargain in all this then is if we're going to have that power, we need to make sure we recognize that it's our constitutional responsibility to honor everyone's due process rights for these matters that we call quasi judicial matters. The touchstone of a quasi judicial matter is, we know it when we see it, right? But it's essentially this. For a quasi judicial matter, we have a public hearing for which we provide additional notice that explains the signs that are out there on the property, right? We're giving additional notice to interested parties that there's an application coming up involving a specific interest, right? And we got a public hearing, we've got notice, and then the decision has to be made by a fair and impartial decision maker, not for the faint of heart here. And the decision has to be made based on the evidence that's presented at the hearing. It has to be made by applying the existing, previously adopted legal standards at the criteria. to the information that's presented to us at the hearing. That all sounds kind of like a court case, as it is. And we just call it quasi judicial. It's just much more informal at the local government level. But from a constitutional perspective, the expectation is that basically as quasi judges, the due process clause requires that we basically do the things that judges do and don't do the things that judges wouldn't do. So when you raise your hand for appointment or you sought office, it probably wasn't the first thing on your mind. What's this part of the job? It's a little weird, a little counterintuitive. You thought, my job is to be a policyman, but wearing the hat for this part of the job, it requires us to be a judge. So there's a third handout at your places. Oh, by the way, I didn't mention earlier, one handout's about risks around electronic communications. And the other handout talks more about the quasi-judicial rules of engagement. And it all seems mysterious and counterintuitive until we step back and think about where does all this come from, right? And it just comes from the due process clause, which says no person shall be deprived of life, liberty, or life, liberty, or property without due process of law. Okay, all right, that all makes sense. So let me just talk about some of the big risks I see around this issue. Let's go to the next slide. Okay, as the quasi judges, you have to remember that, have you heard this phrase, ex parte communication, right? That when your attorney and the CIRSA attorney gets up there and says, hey, don't engage in ex parte communication. What they're basically doing is reminding you of the constitutional obligation, right? Not to communicate with interested parties about the substance of the hearing outside of the hearing. Why? Well, because due process says if an individual's interest is being affected, then everybody has the right to hear everybody else's testimony within that public hearing, right? So it's to use a kind of glib analogy, it's almost the same thing as being, say we have a court case. Let's say you and I owe you money, and I never paid you, and you got tired of waiting around, so you sue me. And tomorrow's our day in court in front of the county court judge. Your expectation from a due process standpoint is, I'm not on the phone with the judge the night before. Judge, look, and it's the same thing. It seems weird, but it's the same thing for you all as quasi-judicial decision makers. The law requires that you not engage with the interested parties. I call it the lonely part of the job. It feels lonely. Because what happens in the news? Right, the front page of the newspaper, big controversial development application coming up in Woodland Park, and as a citizen, what's your natural inclination? I want to talk to my elected or official or my council member and try to tell them why they need to vote no or yes on that application. But as the judge, you have to hold your powder and stay away from that and have talking points. Staff can help you. That make sure you've got some talking points to remind people. It's not that I don't want to talk. And it's absolutely the case that I do want to hear from you, but as the judge, right, I can only engage on this issue during a city council public hearing. And we're saying this to protect you individually. The last thing I want to see happen is, and this goes on in our world all the time, whether we think it's fair or unfair, or whether we think it's for sport or substance or what have you, there will be situations where somebody on some side of one of these due process hearings will try to make an objection and try to disqualify someone as a judge, right, on the allegation that they were engaging in inappropriate communications with the interested parties outside the hearing. And when we say stay away from that, I want you to stay in the game and be one of those 16 people who has the ultimate power. And that's the power to cast a vote on that decision. Okay, so that's ex parte communications. Remember also the job of being a judge requires that we remain neutral, right? And impartial, that we not show bias, that we don't make up our mind before the hearing, right? So I'll give you an example using marijuana. We have a lot of member jurisdictions where they got into the world of marijuana because their voters their citizens put on the ballot an initiative to allow marijuana within their community, even though the town board of the city council decided as a matter of policy at their level, they didn't want it. But the voters voted and they decided, okay, we're going to allow it. Oh, by the way, now that we allow it, we need a licensing board, and that'll be the city council and town board. Right? And we had situations where during those discussions, somebody would say, member of the governing body would say, well, I'm never gonna vote in favor of a marijuana establishment when a license comes before us, because I never wanted them to begin with. Does that sound like a fair and impartial judge of the application, right? So I have to be careful of that. You know, I know the media is gonna try to get to you for these high profile applications and talk to you. Just remind them, hey, you know, I'm gonna wait until I hear the information presented at a public hearing, and then I'm gonna decide. And that kind of thing, okay? So make sure we're neutral and impartial. Don't make any prejudicial pre-hearing statements. Make sure that we didn't touch on ethics in this presentation. We could do that separately, or you're getting training on that. A big risk factor for quasi judicial proceedings is if conflicts of interest are not properly handled. Back in my day in Jeff's shoes, I was advised on occasion where, not the Woodland Park Planning Commission, but we had a decision that was reached and they made a recommendation, and then at the very end, when the votes were being taken, somebody would say, well, I'm gonna abstain. Well, why aren't you voting? Well, I live next door to the project. Oh, I didn't know that. Is that a conflict of interest? Could be, I don't know. It depends, right, on whether living right next door might have the application might have a direct and substantial influence on their financial. Right, or somebody actually did have a financial tie to the application, and they thought it was proper to stay in there and engage in the discussion, but that's not true, right? So if you have a conflict of interest, make sure you recognize that early and deal with it appropriately. If you're unsure, conflict of interest issues, in my estimation, are not like wine. They don't ripen at time when not attended to, right? So your city attorney, your city manager, they love to hear from you early. If you have a concern, you're not sure what to do. You know, I have this potential relationship, but I'm not sure it's a conflict under the code. Give your manager or attorney a call. They can help you. They're not your individual ethics advisor, but they can help you understand how the rules work and think about all the different perspectives as to what's necessary there. Okay, so that's impartiality and conflicts of interest. And then lastly, big risk factor is where we make a decision that isn't supported by the evidence or by our standards. Remember, for quasi judicial matters, we have to set aside our own personal preference. If we have a liquor license application, the mayor says, hey, great hearing. Thank you, applicant. Thank you, staff, for the presentation. Let's discuss this now as council. I say, Mayor, I'll start our discussion. I'm just going to vote no because I don't drink. Is that our standard?
No.
That is not a legally defensible standard. Are there standards that apply? Sure. And it's like the state liquor code is packed with standards, all written in legalese that apply to that decision. There are standards like the applicant, the location has to be at least 500 feet from a school. The applicant has to be of good moral character, whatever that means. But these are all the pre-existing legal standards. So we have to stay focused on those and put our personal preferences aside. It can be a little tougher sometimes. Let's say, do you have what's called a conditional use? Sometimes maybe it's a land use line, a conditional use standard, and we've got a lot of good testimony, a lot of diverging opinions. And we bring it back to council and we say, okay, let's each, everyone gets a chance. The mayor wants to make sure every council member has a chance to say their thoughts. That's the time during the hearing to get out those decision-making standards. They're probably in the staff report, and stay focused on them. Right? Sometimes you get off to a rocky start. Maybe I say, Mayor, yeah, thanks for the opportunity. I'll talk first about this conditional use. I'm going to vote no because I don't like it. Yeah, not the greatest starts, but can we get there? Sure. So then maybe another council member says, well, why don't you like it? Well, I'm going to vote no because I don't like it. Because I don't like the applicant. Well, that's when staff's going to jump in and say, no, it's not a standard. Not a standard.
Lose it.
Right? I'm going to vote no because I don't like it because it doesn't meet our standards. Now we're getting somewhere. Are we done?
No, you need to-
I don't like it. I'm going to vote no because I don't like it because it doesn't meet our standards. Because in particular, it doesn't meet conditional use standard number 4 that says the use must be compatible with the neighborhood. Are we done? No. go even, why is it compatible with the neighborhood? What information was presented at this hearing, either through the staff report or the testimony, the credible, relevant testimony that showed that that use was incompatible with the neighborhood? Oh, well, that's an easy one. I'm gonna vote no because I don't like it, because it doesn't meet our standards, because it's incompatible, because our design standards say you must use wood and stone and have a pitched roof. But this particular application happens to be a squat adobe structure with all sorts of neon lighting, and it's not compatible with the neighborhood, and that's why I'm gonna vote no. What have you done magically from Sursa's perspective? You have now, on the record, articulated the defensible reasons for voting no based on the evidence presented at the hearing. I encourage you in all your deliberations to use what I call Sam's rule of why. And with staff's help, you'll always, right, then naturally get focused on the evidence that's been presented and the criteria that apply, and you'll always have a great discussion if you use that process, right, to make a decision. It's and then lastly, from the citizens' perspective, recognize that even if it's one of those ones where, you know, it was an easy peasy hearing and all the evidence pointed to yes. Nonetheless, I think from a citizen's perspective, it's better, even if we all know we're all gonna vote yes, to say something on the record. Because you're the decision maker. The mayor says, all right, let's talk about this. Anybody want to make a motion? If somebody says, yeah, I just want to tell everyone, thank you for the presentation. I'm going to be voting yes on this application because as mentioned in the staff report, it meets all of our criteria. Right? And now you, the decision makers, have buttoned up your record by saying that on the record, okay? In this slide, there's more links to resources for you on quasi judicial presentations. Last slide I want to mention, last two slides. Let's go real quickly. I got 1 or 2 minutes left. All right, ready? Okay. I try to categorize in terms of practical realities, where do the governing body, where do the liability risks lie in terms of exposures that individual elected officials or elected officials collectively can create for themselves of the organization. I have listed them here. Civil rights and employment practices ones, those are the high dollar, difficult ones to settle, right? Those are ones where the civil rights liability in particular is difficult to attach to an individual unless we're actually going completely off our rails. So the first two categories there. The next three are the ones where there's the biggest risk of individual personal liability, right? As I mentioned earlier, that's willful and wanton conduct, or conduct outside the scope of authority, or breach of ethics or fiduciary responsibility. Those are ones where those circumstances occur. That's an individual personal liability. Some of the other things, challenges to open meetings compliance or open records laws, those attached to the organization, the council as a whole. Land use challenges at the state level usually come in the form of what's called a 106 challenge, where somebody's trying to challenge your decision as arbitrary or not in conformance with your standards. That's not a personal liability. The last two are just give you a sense of some risks that are not covered by insurance, and that's contract claims or taking claims. Okay. And let's go to the last slide, and I'll just wrap things up. Some of the takeaways for mitigating risk, right? Just remember and embrace that policy administrative distinctions. Take the time you need, get the information you need. Have good deliberations. Always good. Always helps build faith and trust in how you do your work. Follow your transparency rules. Recognize that process in and of itself is a government service, right? Yeah, even if some people walk away unhappy, if they walk away saying to themselves, hey, I don't agree with council's decision, but you know what, it was a good process. I feel like I was heard. I feel like I was respected. I feel like they had a respectful and civil debate with one another. What a great place to be in terms of building things, right? Make sure we avoid any reactive conduct that might be perceived as retaliatory. And then always keep in mind that stewardship, that fiduciary responsibility, and the primary job is working collaboratively, right, to fulfill your role as fiduciaries of the organization. Okay. Last couple slides are just some more resources for you about Sursa, together with a slide or two that reminds you of the primary coverages that we provide for the organization. So with that, Happy to take questions you have. I think I've bumped up against time.
Thank you, Sam, so much. Council, do
Yeah.
you have any questions for Sam before
No,
we
no.
wind this up?
I don't have any questions, but thank you, Sam. It was very informative, very, very
Thank you so
thorough.
much.
Excellent, yes.
We need more bling.
We need more bling.
Bling, more bling.
Swag.
Swag.
Council-
My